So a couple weeks ago, a friend came into town and he had to run some errands while I was at work. I let him borrow my car, and unfortunately, he got into a wreck. What happens next? What should I be aware of in that situation?
So under Florida law, there is a doctrine called the dangerous instrumentality doctrine, where the owner of a vehicle, if they give permission for another person to use and operate that vehicle, the owner of the vehicle is responsible for it. So I would say that what you can expect next is probably a claim from the other driver if they were injured.
To me, not the person that was operating the vehicle.
So they could potentially sue the other person, but likely they're going to go after you because you were the owner of the car.
So it doesn't depend on whether they were listed on the policy or not.
It does not. What is important in these cases is if you gave permission to that person to operate your vehicle.
What if they were at fault, the person that was involved in the accident with me? Am I still responsible for the damages?
You are. So if the person that you lent your vehicle to is the at-fault driver, as the owner of the vehicle under Florida's dangerous instrumentality doctrine, you are responsible for the negligence of the person that you gave permission to operate your vehicle. So in other words, be careful who you lend your vehicle to.
Yeah, I'll say. Is there a difference between lending your car once versus them driving it all the time? Like if you let them borrow it for an extended amount of time?
There is, but this kind of boils down to the fact that once if there's a one-off time, there might be an argument that, I guess there might be some sort of liability argument or against that. But once you have consistent use of the vehicle, it essentially establishes that permission, and there's really no workaround to the dangerous instrumentality doctrine.
And let's say in a different scenario, the friend got hurt. Could they still file a claim through your policy?
They could. They could go under your underinsured motorists if indeed the other at-fault driver's insurance does not cover the full extent of their damages.
And what if the other driver involved tries to sue you since it's your car?
At that point, I would imagine that your insurance will contact you, but that is certainly a possibility under Florida's dangerous instrumentality doctrine.
Does it matter what my friend was using the vehicle for? Like if they were at work versus just going to run errands?
It does. So if your friend is using their vehicle in the line of duty, then their employer may also be liable for any damages that they cause while using your vehicle.
Are there situations where the friend driving could be personally liable instead of me?
Absolutely. Yes, there are definitely circumstances where that could be the case, and your friend could be subject to a lawsuit. But most of the time, regardless of whether or not they are liable, under Florida's dangerous instrumentality doctrine, the owner of the vehicle is almost always liable for any negligence of the driver of the vehicle.
What's one thing you'd tell people before they ever hand their keys over to someone else?
Be careful. I know that it's tough to say no to people, but always think about the ramifications of any potential negligence of your friends.